Good morning. Welcome to our second day of April oral arguments. Calling our first case, Cavazos versus American Athletics. Good morning again.
Good morning, Your Honor.
You have time for rebuttal, but we ask that you reserve that and you keep track of that yourself.
Thank you. May it please the court, Robert G. Kamenek, and with my colleague Adam Wynn, we represent the plaintiff appellant. I'd like to reserve 2 minutes for rebuttal or the remainder of my time. Okay. As the court knows, this is a case involving the interplay between the public building exception and code provisions. I know we have some people in the audience. I thought I'd take at least 30 seconds to go through a little bit of the factual situation so they can appreciate the argument. Hopefully they appreciate the argument. But this is a personal injury case, as the court knows, arising from an incident in October 2017 where the minor here, GC, 3-year-olds, was in the bleachers over at a middle school in Davison. He's on the 15th row, and he slipped between the floorboards and the seat boards. There was an opening there, and I think everybody's been on bleachers. You understand what I'm talking about. He dropped 17 feet, he hit his head, and he was severely injured. At the time this happened in 2017, there was a code provision that required that opening to be no wider than 4 inches. And it was, at that point in time, 17 inches. Davison School District, now call them Davison for the rest of the argument, had been advised of that 9 years before this incident, because Davison, as many municipalities do, they hired a contractor, a specialist, who told them, which happened to be American Athletics, a co-defendant in this case. The importance of the 4 inches is as follows. There's code provisions and ICC provisions that explain that the vast majority of bleacher cases, injury cases, involve minors under 10 years old. And here, what happened is the 4-inch requirement really represents the sphere of a child's head. And that's why it's 4 inches as opposed to anything else. So what happened here was, in our mind, expected. And the reason why, according to the deposition testimony, Davison didn't do anything about it is they mistakenly thought that they were grandfathered out of new code provisions. So they knew about it. The testimony is very clear on that. But I digress because we have to get to the legal issue. So I hope that gave everybody a little bit of a background so they can appreciate this. So you've got a code provision here that's designed specifically to protect children. What does repair and maintain mean in this context with respect to a condition that's out of code? Our position is very clear on this, that you do have a duty under the statute. You have an obligation to repair a defect if the code says it's a defect, and you have a duty to maintain bleachers, for example, up to code specifications. Why is that? Well, I think there's about 3 or 4 main reasons. Number one, when you look at the statute, I'm suggesting to the court the proper way to interpret repair and maintain, which is the obligation portion of the statute, is to interpret it in light of the liability portion of the statute, which talks about a dangerous or defective condition that has to be remedied. And I think the first rule of statutory construction is to have the terms consistent within the same provision rather than anything else. I know the defense is going to get into what I would call one of the statutory canon orthodoxies, that you have to read the provision narrowly. But quite frankly, that provision, as this court issued, I believe in Milne about 3 weeks ago, that doctrine or that statutory canon cannot trump the actual words of the statute. So I think that the best way to interpret this is, as I just indicated, look at the actual terms in the statute itself, make sure the obligation, which are the duty provisions, repair and maintain, are consistent with the liability provisions.
I'm sorry, Mr. Kamenek,
I'm sorry.
I'm troubled or struggling with the fact of whether or not this is even a public building. And I recognize the procedural history of this is a little odd to get up to us, right? The trial court found that it was, and then proceeded on to the repair and maintenance question. The school district did not appeal that. and then I believe affirmatively said in both their response to your application in the Court of Appeals and in response to the application here, that while they disagreed with it, they were not challenging that decision. I know that amicus has put forth an argument of why the bleachers would not be a public building. I mean, I think you would agree that it would have to be a public building in order for us to get even to that second question of repair and maintenance, correct?
Agreed.
So what do we do with that if we don't have a decision on whether or not it is in fact a public building?
Well, a couple points. At least at this stage of the proceedings, I don't think it's properly before the court. And I know that's the premise of your question. I understand that. Okay.
Mm-hmm.
And so I don't think it's properly decided here. But then again, the court uses its resources carefully. I think that the proper way to handle it, if we believe it's still an issue that's open, is remand it back to the trial court for briefing.
Is it a little odd, though, if the defendant chose not to challenge it?
It is.
I mean, it was decided against them. This isn't an issue that was raised and not decided, and then, you know, perhaps we could say that. But to have affirmatively chosen not to challenge that determination.
And I may be too generous to the defense. God forbid I was on that side for a lot of years here. But I thought that the trial court opinion assumed it was a public building.
I
Because then it ruled-
didn't read the trial court as assuming. I think the trial court actually cited a couple cases and
Right.
determined that it was. So
Right.
adversely determined that question against the defendant. And while they maybe or maybe not, I guess it's a question of whether or not they needed to actually cross appeal it in order to get it up, they affirmatively didn't even make an argument about it, even if they didn't have to officially cross appeal, right? So it hasn't been challenged, and so I don't think the Court of Appeals didn't decide it because it wasn't presented to them. It would just seem to be in an odd posture for us to send it back on a question that they assumed that they were okay to live with.
If the court were to determine, to use the vernacular, that Davison had its chance and didn't take advantage of it, I would agree with you, to put it in plain English. And that would be that the issue's gone. But if not, then it can be considered on remand. But
So the issue is gone, but, and I can appreciate that, but what do we do in looking at whether or not we are going to opine on that second question if we're not sure about that question, about the first question of whether or not it's a public building?
I would encourage the court to do the same thing that I believe it has done in other cases, say that the parties have not contested that. It is a public building for purposes of this case, and then go ahead and set the law with respect to repair and maintain in the context of code. And if I may, and I understand the question and I understand the limitations, but in light of the briefing that we gave you on Rennie, there is a need to address this issue.
So would it be helpful to address the issue, though, if that first question is undecided? I mean, obviously, we take cases because they have big impact across the state. So I think the challenge is, if we were to, get to Rennie and talk about Rennie and how it applies to this case, would it still be helpful in light that there's a question about whether bleachers are public buildings?
Yes,
Okay.
because the court would have the opportunity to, in my mind, reevaluate the Rennie decision with respect to at least allegations made about design defects in buildings,
Okay.
period. Now again, and I don't want to wander too far, so I'll come right back, but, at the end of the day, our case is a little bit different from Rennie. As you know, Rennie, there were two factual allegations in the case. One was design defect and one was repair and maintain. And when you read through Justice Weaver's concurrence, she said the court never even got to the second question. It just resolved the design question. So let's keep that in mind. Then you go to our complaint in this case. There's no mention of design at all. So now I'm coming back to the answer. We have a situation that really was not addressed in Rennie. And then what you had, from my point of view, from what I've read, but then you have spin-off, no offense meant to the Court of Appeals, then you have spin-off decisions from the Court of Appeals based on Rennie and based on a case where there was the Supreme Court addressed only whether or not an allegation of design defect, not an allegation as we have here today of repair and maintain, whether or not that fell within the public building exception. And then on top of that, and I guess I'm on a roll, so I'll keep going, but on top of that, they got it wrong. And with due respect to the justices back there, I don't like saying that, but my God, it's one of the most narrow, let's pick the right definition from the dictionary decisions that I've seen since Robinson. And so
this is very helpful, because my next question was going to be, do we need to overrule Rennie to agree with you, or do we just say it doesn't apply here? What do we work around Rennie? How does it work here?
well,
I know, first choice would be get rid of Rennie, I understand, but do we
Right.
have to get rid of Rennie?
you do not have to overrule Rennie, because Rennie had, and I'll just repeat myself, but I think I made it clear earlier, because you had allegations of design defect and you had allegations of repair and maintain, separate and distinct from design defect. And again, that's, if you read through Justice Weaver's concurrence, she makes that point. She said you really, and I think it was remanded back, if I recall, on repair and maintain.
But how does that make sense if there's two alternate theories? The court can't, they have two different claims. So the court can't rule on each claim? It only rules on one claim?
No, the court can rule both, but in Rennie, the Supreme Court only ruled on one claim. Maybe I didn't understand the question, Your Honor, I'm sorry.
Well, they sent it back on repair and maintain, if I'm remembering it correctly, to investigate whether there was a gutter on this rest area before that hadn't been maintained there. So it sent it back on that theory, but if there's a design defect theory, claim, alternate theory, it's not clear to me why it would be dicta to rule on the two theories before the court. One theory fails, the other theory might be able to go forward depending on the facts. How does that, in other words, I don't really follow what Justice Weaver was saying.
Well, the ruling with respect to design defect, given the allegations in Rennie, is not dicta. That's the holding of the court. But the majority did not address the alternative theory.
I agree, they remanded it and said there might be facts. What they said is if there was a gutter, I think what they were saying, if there was a gutter before, or downspout before that wasn't maintained. It sort of gets to my question, to boil this all down to its bare essentials. I just want to make sure I understand your position. Because government buildings, a lot of them are very old. And a lot of them, and here we have a building that was, for all we know, built to code at the time it was built. I don't think you're challenging that, are you?
No, that's a fact of the case, correct.
So your position would be that every municipality and governmental unit in Michigan has to bring all of their buildings up to code? Is that's the position you're taking? Otherwise, they would be liable for, they would be giving up their defense of immunity. Is that what your position is?
Close. Yes, they all have to.
So for example, you have a building where, 100 years ago, the stairways were narrow and the hallways were narrow, and maybe there weren't even emergency exits. You can't build a building like that today. So if there was a fire or there was a problem and people couldn't get out of the building, they would be liable because they didn't either tear the building down or do something to make the hallways and staircases wider, to bring them up to code. Is that your position?
I understand, Your Honor, but otherwise you are excusing the municipality from the construction code statute that
Well,
says
we
they
have,
have to.
I'm just trying to understand the extent of what you're saying, because, I came from Macomb County. We have a court building that's built in the 70s.
Right.
That there's a lot of places, Marquette comes to mind, other places have historic buildings. I'm just wondering what the rule you're advocating, what would it require municipalities to do?
To bring the building up to code to avoid a dangerous situation. I mean,
Or tear buildings down and start over?
I'm not suggesting that.
Well, a
we're
lot of
dealing
them,
with
if you can't bring it up to code, you'd have to tear it down, wouldn't you?
No, you can, well, here, first of all, I have to address it in our case. It's easily done, right? I got to put the riser planks
Our
on.
ruling, you've been
I
here
know.
before, but our ruling doesn't just apply to your case, I don't think.
I understand. I
Okay?
understand.
It applies beyond bleachers on a football field to every government building in Michigan,
Right,
I
but-
think.
But otherwise, you would be leaving you would have old buildings and be giving the government a pass on older buildings that are dangerous. When you have a statute out there that says you have to bring them up to code, that's the importance of the construction code statute and its interplay here. It applies because same objective in both statutes, it applies the same, there's not like there's some exception out there.
I understand, I just want to
Okay.
make sure we understand the extent of what you're saying. Your position is the governmental units have a duty to put aside whatever else they need to do with the public funds that are under their control and spend them all bringing buildings up to code until that work is accomplished.
They have to bring them up to code. I'm not talking about the resources. The other thing they can do, and I know my time ran. The
Well,
other thing they can do.
that takes resources, doesn't it?
I'm sorry?
That'll take some resources, it's not gonna be free, you're not offering to pay for it. are you?
Absolutely, and the resources it would take come out of the budget, and they've got to do it. But they have an alternative under the statute, Your Honor. They can rope it off. They can not use the building. They can use an alternative building. And I'll end it on this point, and then I'll sit down. You're being very kind to let me go. I was going to bring up, look what Vassar did with their bleachers. Exact same generation. They had a problem with their bleachers in 2017. They closed their bleachers down. They told everybody to bring their lawn chairs to watch the football games. So under the statute, you still have another way to address the situation. You don't just have to repair and maintain.
So if you have an old court building, we can just shut the court building down and we can conduct court from a tent somewhere? Is that the idea?
Your Honor,
We'll rope off the court building?
I understand the extremities that you're going by way of the examples, if I may be so
I'm really
bold.
trying to give mainline, like, the next case that we're gonna, you know what I mean? I'm not trying to come up with extreme hypotheticals. I work in a court building, that's why they're kind of present in my mind, but I could give lots of examples. We could say township halls or city halls, we could say school buildings, we could say all sorts of things that would be impacted by this ruling. And I'm just trying to understand what I just want to understand your position. This would apply to everybody, and their obligation would be to bring everything up to present code, and every time the code changes, they'd have to do that again.
But the
Because the
stat-
code changes every year, every 5 years, whatever it is, the BOCA code or whatever the codes that they're relying
And
on.
as they would say in Jeopardy, my final answer here is very simply that it still has to be a dangerous or defective condition. Let's not forget the rest of the statute. So, repair and maintain, yes, but they have to remedy a dangerous or defective condition. If it's not dangerous in your example, they don't have to do it.
Thank you very much.
Can I say a quick, Counsel, isn't there a little bit of an analogy to Justice Viano's questions in that the Americans with Disabilities Act requires accommodation and requires modifications and requires basically having to maintain codes and having to do repair to existing structures that are government buildings, is it not?
Yes, and the analogy would be plugged directly into the notion that you take a look at those statutes on a federal and state level and compare them to the construction code statute here. And it says, with respect to buildings, you've got to do what you've got to do. And we also have a housing statute in Michigan that's not cited. I did not bring it up in the brief, but you can't let a dangerous building sit out there. So, and that may be part of the answer to your question,
And
Justice Viano.
isn't that also analogous to fire codes as well?
Well-
These codes change and you have to modify in order to keep up with the requirements that is set forth.
I
It's not
think,
actually true, is it? So like, for example, fire suppression would only be required if you did a substantial remodel. You wouldn't have to put fire suppression in older buildings. And even under the ADA, Justice Bernstein, I don't think has it exactly correct. You're not required immediately to conform to all the standards under the ADA, probably some of them, but others only come into play, I think, again, when you do a substantial remodel or rebuild. But that won't be the law anymore, I don't think, if we rule the way you're suggesting. That's all I was pointing out.
well, and agreed, and remember, under the statute, you have to have constructive or actual knowledge too, and I didn't get into that part of the statute, but it's there, the public building exception. I'm sorry, I went over my time.
Thank you very much.
Thank you.
It's not your fault.
Nice to hear.
Good morning, Your Honors. May it please the Court, my name is Christopher Marker. I represent defendants appellees Davison Community School District, Daniel Romzik, and Philip Tome. At council table is also counsel for American Athletics. He's allowed me to take up the 15 minutes of argument as the question presented by the court is strictly in relation to the governmental immunity issue. Specifically, on September 15, 2023, the court ordered further briefing and argument on the question of whether a governmental agency's non-compliance with a building code provision constitutes a failure to repair, or meet its obligation rather, to repair and maintain a public building under MCL 691.1406 and Rennie. In response to this question, the district would answer no for two primary reasons. First, the lack of riser planks on the bleachers at issue in this matter constitutes a design defect and not a failure to repair and maintain, regardless of whether a code violation is present pursuant to the narrowly construed plain language of MCL 691.1406. Second, to the extent that this court finds the presence of an alleged code violation determinative in this matter, there was in fact no code violation present with respect to the bleachers on the date of this incident. With that, I'll waive my no fire, anticipating some questions on that second argument.
Explain your last point.
Sure.
There's no code violation on the date of the incident?
Yes. So the ICC 300 is the standard in the code that the plaintiff and appellant relies on in this case. It's been briefed in the amicus brief by the Michigan Township Association. The plaintiff is cited to the ICC 300. I'd rely upon and instruct, or I guess have the court review the Michigan Township Association's amicus brief strictly for background information on grandfathering clauses, because they're not specifically called grandfathering clauses in the Michigan Building Code, in the Michigan Property Maintenance Code, in the International Property Maintenance Code. None of them, you're not going to find something in a table of contents that says grandfather clause. Instead, what you will find is violations clauses and alterations clauses. Those are the triggering events that require a building, if the bleachers are in fact a building, to be brought to present day code. So let's examine the ICC 300 because it does just that like any other code in this nation and in this state. First, section 102.1 states that the ICC 300 applies to all new and existing bleachers, subject to not only chapter 1 as plaintiff puts in their brief, but also subject to chapters 2 and 5 of the ICC 300. Chapter 5 relates to existing bleachers. Section 501.1, general, states that existing bleachers, folding and telescopic seating, and grandstands that exist prior to the adoption of this standard shall comply with this chapter, that's chapter 5, and the applicable provisions of chapter 1. Section 501.3, violations, says where deficiencies are identified, the owner shall have until, and then there's a bracket that says date to be inserted by the jurisdiction to abate the unsafe condition as deemed necessary by a code official. The ICC 300, section 202, defines a code official as the official or other designated authority charged with the administration and enforcement of this standard, or a duly authorized representative. These bleachers were never red tagged. The district did not receive an ordinance violation. There's no evidence that any code enforcement officer, as defined by this code, ever once said these bleachers are defective and you need to remedy them. Finally, and this is the most important part, it can be confused, I suppose, with 504.1, which is the 4-inch sphere rule, but realistically, this is 501.4 of the ICC 300, specifically titled alterations. This is the grandfather clause. You'll find this again throughout other codes, and again, it's cited and examples are provided in the amicus briefs. It says, alterations to any tiered seating shall conform with the requirements of this standard for new construction. It goes on to say, and this is the most important part, portions of the structure not altered and not affected by alteration are not required to comply with the requirements in this standard for a new structure. What does that mean here? These bleachers were constructed in the 1960s. At one point in time, they were accompanied by wooden, unattached bleachers. Those were later torn down, but there was never any alteration to these bleachers beyond the simple repair and maintenance of them by turning a screw or turning a bolt and ensuring that the bleachers themselves were in proper working condition. With no alteration, there's no triggering event to bring them to present day code, and that's how codes work. That's why private property owners are not required to bring their buildings or homes to present day code unless they make an alteration. It's the same thing here. It flows logically, and that's why it's included in the ICC 300. That's why, again, you're not going to see anything titled grandfather, but it is in the alterations and violations sections. That's how they operate. I'd be happy to address any further questions
So-
on that issue.
I want to back you up. Do
Sure.
you agree that for purposes of this case that we can assume, as the Court of Appeals did, that the bleachers are a public building?
Your Honor, I did not brief that issue, strategically focusing on the design defect issue, simply because that was the issue that we had won at the lower court, and we chose not to tear away from our principal argument. However, to the extent that this court finds that the Court of Appeals got it right, but for different reasons or for the wrong reasons, I think the court is perfectly or in the right position to analyze that issue. And if it finds that the building was not, or the bleachers rather, were not a public building, which is a part of the analysis, then we don't have to go any further. You don't pass step one.
So it was decided against you in the trial court, and you did not challenge that on appeal?
That's correct,
So-
because, yes, I apologize.
So what would be the basis why we could say, well, Court of Appeals, you should have taken up this issue and decided it on that, when you chose not to challenge that?
Sure. Again, the reason that it wasn't challenged is because we had won the issue, but specifically on that issue, and I can't quote you the case off the top of my head, but in researching over my career, I know that there's a case out there that says that if the trial court or the Court of Appeals got it right, but for the wrong reason, this court can explain why the right reason is that it got it right, meaning if it's not a public building, but the Court of Appeals assumed it was and went over that question, this court has the power to say, yes, you got it right, we can affirm your decision, but here's why you actually got it right, it's not a public building.
I 100% agree, and I don't want to, and I could maybe even agree that you didn't need to cross appeal in order to do that. But your party, or I don't mean to single out you, your
Yes.
client, has not actually argued right result, wrong reason for public building. And amicus has raised that argument.
Right.
But so, I totally agree, we do it all the time, right?
Sure.
And Court of Appeals does it, right result, wrong reason, and you know, what the preservation requirements are for that. But that needs to be argued to us. And that's what I'm struggling with. I mean, and maybe you're saying amicus did it, or
Sure.
anyway, and
I
that's
mean,
sufficient.
I would rely upon the submissions on the amicus brief on that issue. Again, the strategy was we didn't file a cross appeal on the issue because we had won the issue. Why
Right.
waste the court's time and resources on an issue that we had already won on a cross appeal that would have resulted in nothing more than an opinion from the court, an advisory opinion as to the public buildings, not necessarily something where actual relief could be granted because we had already won on that issue with respect to design defects.
You didn't, oh, okay.
Yes. Moving on to the first issue, specifically, that's the difference between design, or I should say the interplay between the words design, repair, and maintain. The first sentence of MCL 691.1406 says that governmental agencies have an obligation or a duty to repair and maintain public buildings under their control for use by members of the public. Now, it's important to note that the legislature only used the words repair and maintain, and I know this court is well aware of Rennie, but food for thought for the court. Later on in the Governmental Tort Liability Act, specifically section 691.1416, that is the sewer backup exception to governmental immunity. It is another portion of the Governmental Tort Liability Act. That was last amended in 2002. MCL 691.1406, the statute we're here to talk about, last amended in 1970. But in 2002, the legislature, in its definitional terms, with respect to the sewer backup exception, said that a governmental entity can be held liable not only for a failure to repair and maintain, but also for design defects. So what does that mean? If we read this statute using only the plain language and also using the canon of construction known as the expression of one thing is to the exclusion of the other, the Latin phrase is expressio unius est te exclusio alterius, the expression of the word design within the sewer backup exception, MCL 600.1416, is to the exclusion of the word design in MCL 691.1406, meaning repair and maintain is expressed in the specific exception we're here to talk about today. It's not design is not expressed, but the legislature knows how to make a governmental entity liable for an exception to governmental immunity because it has done so in a later exception to the very governmental immunity afforded to public entities pursuant to MCL 691.1407. With that being said, Your Honors, the Rennie decision makes clear that the first sentence unequivocally establishes the duty of governmental agencies to repair and maintain buildings. The second sentence does not expand that duty, and it's not suggestive of an additional duty beyond repair and maintain. That's not dicta, that's what the Rennie court focused on. Finally, I would note this just in response to the Vassar issue that counsel raised. I hold in my hand appendix page 1058 from our initial briefing. It is a letter dated August 31, 2017 from American Athletics, the co-defendant in this matter, to Vassar Public Schools. In this letter, it says, "Thank you for having us in yesterday to assess the condition of your district's athletic seating. The field data collected by our inspector will be reviewed carefully and presented in a written report that will include a detailed description of the equipment's condition, including photographs and line drawings." The relevant portion here says, "Alternative seating should be considered until our office has completed a review of the field data and submitted a recommendation on corrective action, including repair or replacement of the football grandstands." There was no letter such as this authored in 2017 following the report at issue in this case, the 2013 report, or at any point in time prior to this incident from American Athletics saying you should, based upon the information that we observed at the time of our inspection, consider roping off your bleachers. Nor was there a code enforcement official who came into Davison and said, you cannot use these bleachers. We're roping them off. You have to use alternative seating. There was no notice of that violation with respect to an actual enforcement mechanism. With that, Your Honors, I'd respectfully rely upon our briefing unless the court has any further questions for me on these issues.
Does it matter, though, that it was a 17-foot drop?
Factually, Your Honor, I don't know that it does, simply because the code was not violated here for the reasons that I've stated. The bleachers go up 17, 20 feet. However high they go, the law remains the same with respect to repair and maintain. This is not something like we had in Rennie where there was allegedly a gutter at one point in time and then it was failed to be maintained because it was taken down and created ice and snow. No amount of repair or maintain or upkeep or maintenance to these bleachers would have resulted in the affixation of riser planks to the bleachers because they never existed.
So it doesn't matter that 17 feet, it could be, your perspective could be, it could be 20, 50, 100 feet.
That's correct, Your Honor.
Okay, I understand. Thanks.
I don't see any other questions.
All right,
Thank you,
with
thank
that-
you both. The case will be submitted.
Thank you, Your Honors.
We used all of your time and then some. Yep.
But can I ask a quick question, though? I apologize. Can you respond to the question that I just asked, which, does it matter if it's 17, 20 feet, 50 feet?
Yes, briefly, please.
Yeah, please.
Thank you, Your Honor. Yes, it does matter because the code provision provides that if it's a lower seat in a bleacher, you don't have to do anything. So if it's under 30 inches, you don't have to go ahead and add the risers. But so the significance of the 17 feet is indeed very important because that kicks in the requirement that you have to have the risers and you have to reduce the gap to 4 inches.
Thank you
Got
very
it.
much.
Thank you.
Thank you, Your Honor.
Thank you both.